Hello, everybody. Good evening here in New York and good morning in the Philippines. So it's been a while since I haven't done the Facebook Live, but Happy New Year to everybody. So we'll just wait for others to join. Can you give me a feedback whether or not I'm okay as far as the volume is concerned? Pakisulat to lang sa comments section, please. Hello, Ma'am Jamie. Okay. Yes, so I have no specific topic for today. So the game plan is if you have specific questions, can you just write them down on the comments section? Then I'll try to grab whatever question I would see on the screen, and then I'll try my best to give you a response. So just a reminder that whatever advice I will give you, that this does not create a client-lawyer relationship. Thank you, Ara, for giving me that feedback. But so isulat nyo na lang kung ano yung mga tanong nyo and I'll try to respond as soon as I can. So paunahan na lang tayo, right? Hello everybody. So yan, marami na nag-join sa atin. So I'll read the first question kung sino man ang magtatanong dito. Okay, so I'll grab this one question though, but there is no name written down. So it's a Facebook user. Can I petition my mom together with my sister who is 10 years old? Okay, so I'm not so sure if you are a green card holder or a citizen. But let's just assume that you are a U.S. citizen. So only U.S. citizens can petition parents. So yes, you can if you are a U.S. citizen, and the processing time is normally 1 year. So nandito na yung parent mo. But does that include your sister? No. The best strategy will be petition your mom first. Then once yung mama mo nandito na, she can petition your sister. Then a matter of 2 years, kasi green card holder pa siya at that time, your sister will be here. If you're going to file for your sister, that will be a 23-year waiting period. Okay? So I hope that I answered that question. Mr. Lemon, hello attorney. For same-sex partner, pwede bang dyan na lang sa US magpakasal? Waiting for ID na ako. Well, it depends, boss, no? So kung may visa siya, so I presume may tourist visa siya, it's a tricky question in the sense na as a tourist visa holder, if the intention is for your partner to come to the US and get married, then wala namang prohibition on getting married. But if the plan is to get married and then apply for a green card later, then that's fraud. Okay? But there are ways to actually do that legally speaking. I would recommend that you consult with a lawyer to make sure that you do it right. No? But then again, the general premise is if the only intention is for you to come to the US or the partner to join you in the United States to be able to get married, but still do consular processing, ibig sabihin yung partner mo will be able to apply for appear for interview at a consular office, di walang fraud doon. But if the game plan is for that partner to come to the United States on a tourist visa, then apply for a green card later, then that's fraud. And it could be a fatal strategy. But it can be done in a legal way. So I would recommend that you would ask a lawyer to guide you. Okay, so again, dumadami yung questions natin. As much as possible, I would want to limit the conversation for 1 hour because I have another consultation after 1 hour, right? So, we'll do this. Kung ano na lang makikita kong mga tanong dito, pasensya na talaga pag hindi ko mabasa yung question nyo. Car, hi attorney, ask ko lang po, 2-year green card holder ko, gusto ka sanang mapetition anak ko, pwede po ba? O dapat asawa ko na US citizen? So, well, it depends kung anong edad yung anak mo, right? But let's just assume that your child is below 21 years old. Then to answer the question, yes, you can file a petition for them. The waiting period will be about 2 years. Now, kung ang asawa mo is US citizen naman, and ang anak mo less than 18 years old when you got married, then your husband or your spouse could basically file a petition for the child, and then the waiting period is about a year. So, mas mabilis kung US citizen yung petitioner. But the question remains kung anong edad ng anak mo at the time of nagpakasal ka. Carissa, good morning, attorney. When you get pregnant while you are on the immigration PWD, is still in process. Would that be a problem? No. So yung anak mo will automatically be included in the petition. So don't worry about that. Okay? Hindi siya maging problema. You could still be able to bring your child with you. Maria Rias, I am on H1b. If I happen I married a resident, how fast can I get my resident visa? Okay. So fortunately though, the visa category for a spouse of a green card holder is still current. Ibig sabihin, if you decide to get married, then your permanent resident spouse can file a green card application on your behalf. And the process now more or less depends on the local office kasi ang mag-handle ng green card interview. So depende kung saan ka located, the green card interview can happen 9 months to a year from the time you file your green card. Hello Sir Ricky. Sir Jude, good evening boss. Attorney, question for my sister. Can she petition a child that she gave up for adoption? So, a little bit problematic to boss. Kasi the act of if you would let go of your child to be adopted by somebody, you lose the parental control and authority. No? So, hindi mo siya ngayon mapetition ulit. Because, in effect, that's legal abandonment kasi eh. So, you basically are no longer considered a parent in the eyes of the law, right? So, hindi mo na siya mapetition ulit. But if you would want to get more detailed conversation around that, just send us a message, boss, and we'll talk separately. Juan Carlo Antonio, hello, boss. Kumusta? How's New Mexico? Pwede po ba mag-tour outside the US ang isang H1b holder for a month? Makapasok pa rin ba US? Yes, boss. You have a visa, US valid H1b Visa. So, pagpasok mo, gagamitin mo lang yung H1b Visa mo stamp to be able to enter the United States. Mr. Facebook user, regarding po sa CRBA ng baby, kailan po ba present ang mom and dad? Pwede po bang guardian? As a minimum po, the non-parent may be able to join the child for the CRBA interview. Now, there are provisions, mas mabilis sana kung nandoon yung both parents, right? But for whatever reason, the biological parent na US citizen cannot join the interview. Pwede rin. May extra form na pwede i-fill out. But a guardian is not necessarily allowed to join that because there might be questions specific to kailan na-conceive yung child, kailan nakita yung biological parent. So the rules require the non-US citizen parent to be with the child for the interview to be able to answer personal questions. TB, how do you pronounce that? Maria na lang. Okay, I want to be a US citizen, but I'm still a J1 visa holder. Is it possible to have another kind of visa since I will be done with my visa by 2023? So, depende po, no? The question is, are you subject to the 212E? So, are you required to go home to your home country for 2 years before you can apply for another visa? So, if you're coming for a J1, there's a lot of routes for you. You can go to H1B, or if you are not subject to you're not subject to 2-year home residency requirement, pwede kang dumiretso ng green card application if you are married to a US citizen or a green card holder. Then you have to be a resident first before you will qualify for a citizenship. Okay? Now, how long you will become eligible for citizenship depending on anong basihan nakuha mo yung green card mo. So, if it is based on marriage to a US citizen after you become a green card holder, that's 3 years. But other than that, you have to wait 5 years from the time of your green card issuance for you to be eligible for citizenship. Grace. Oscar lang po, the sponsorship about nanny, caregiver, housekeeper na may nag-sponsor but they can sponsor even undocumented yung i-sponsoran. Well, if the beneficiary is already out of status in the United States, so any employment opportunity is closed for them. So, ibig sabihin, they will never be able to get their green card based on employment-based petitions. Kasi their being unlawfully present will stop them from getting the green card. Except, kung ang unlawful presence nila is not more than 6 months. So I would recommend that you consult a lawyer to really know your options. But in general, pag kunwari, you're unlawfully present na in the United States for 6 months or more, employment-based is not an option for you to get your green card. The only option that you could get your green card is if you are married to a U.S. citizen. Okay. Another Facebook user here. I petitioned my husband I-130 and takes so long sa service center in California. Can he apply for a tourist visa? So, the tourist visa application is really tricky, no? Because it's discretionary upon the officer, the reviewing officer. So, even if meron kang, there are cases kasi na even if may mga pending immigrant petition ka, some people could still get the tourist visa. At the end of the day, at the time of the interview mo is for as long as you would be able to convince the officer that your visit to the United States is just temporary and you would be able to demonstrate strong ties in your home country, then there is a chance of you of the applicant getting the tourist visa. Though mahirap talaga 'yon, no? But I'm not saying that there is no chance. So, kung if you would actually visit my YouTube channel, US Caracal Immigration TV, meron akong series of Facebook Live videos then. You would basically watch that to increase your chance of approval. But good luck on your tourist visa application. Hello, Ma'am Ana. Ako silingan. Okay. Facebook user. 2017, I got NOS but was sent home by my visa sponsor due to pregnancy. And then, 2021, I came back to the US as a J1 teacher again, but this time, subject to 212 ako. Attorney, is there possibility na makakuha pa ako ng NOS? If yes, how po? My recent visa is 1 year lang and expiration is June 2022. Okay. So, yung NOS mo na nakuha before, hindi mo magagamit sa new application mo ngayon because when you re-enter the United States on another J1 visa, then that's a different program. That's why you become subject to the 212E. So, for those na hindi na nakikinig, yung 212E, pag J1 visa holder ka, pinapauwi ka to your home country and spend for 2 years there before you could get another visa or green card application. Ngayon, sa case mo ma'am, while an option pa rin yung NOS, but yung NOS ngayon, the common grounds lang na magagamit mo is if you have a US citizen child or if you are married to a US citizen. But based on the EVP guidelines ngayon, mahirap makakuha ng approval on the NOS. So I would recommend that you consult a lawyer kung pwede ka bang mag-avail ng exceptional hardship. No? So again, the facts given are not enough for me to be able to give you a specific guidance. Car, so follow-up question lang to. 10 years old po siya. Dapat po ba siyang i-adapt ng asawa ko kasi sa birth certificate niya sa Pinas is ano? Okay, so ma'am, the US citizen, yung spouse mo could basically petition your child kasi 10 years old pa naman siya. So then the waiting period will be about 1 year, nandito na rin yung anak mo. Okay. Marami akong mga Facebook user ngayon, no? Takot maglagay ng pangalan. But anyway, I would respond to the question. I would like to ask if it's possible that my fiancé from US can apply a fiancé visa petition. He's 60 years old. Same-sex po kami. Yeah, we have a lot of cases on a fiancé visa na same-sex naman. And it doesn't matter kung hindi kayo parehong edad. But in the Philippines, medyo mabagal lang ang pagpaprocess ng fiancé visa ngayon. No? What is required lang naman for the fiancé visa is that you've met in person within the last 2 years from the time of filing of the fiancé visa. Sorry, follow-up lang kay Car. Your spouse doesn't have to adopt the child to be able to file the petition. But kung yun talaga yung gusto niya na i-adopt yung anak mo, then he could adopt your child mas mabilis kung nandito na. Okay, Jen Camilla. I am in the US on a B visa and planning to adjust status to H1b. How many extensions can I file? Dahil almost 4 months na ako dito, I heard that 2 years na daw extension dahil sa COVID. Is that true? Okay, so you are actually changing status for H1b. I just don't know kung ang petitioner mo is CAP exempt or not CAP exempt, but H1b application can be premium process. So even if you are on a B visa, which you are given generally 6 months, and if your petitioner is willing to file a premium process, your H1B can be approved in a month. So you don't need to really extend your B2 because pwede mo makuha naman ang H1B in a month, right? But I'm not so sure if you're referring to the extension of the H1B. If you are referring to the H1B extension, then your H1B can be the lifespan of an H1B is up to maximum of 6 years. So normally it's given 3 years, and then after that it can be extended year after year, maximum of 6 years. And I hope that I answered that question. Hello, Ma'am Vilma Albania from Hong Kong. Hello po. Hello, attorney. My mother-in-law came here as a B2 and was filed by her daughter, a US citizen, last December 21. Nag-file po kami ng change of status as immigrant January 4 and received na po ng January 6. Nag-expire na po ang kanyang I-94. Magka-problema po ba siya? Hindi po. She is still in status. Then, normally pag parent petition, wala nang interview. Very rare na nag-i-interview pa ng parent. So, I think lalabas na rin yung green card niya o work permit niya mga 6 months from the time you file. Says, sir, kung may green card na po dati pero expired na, paano po maka-enter ulit sa US if gusto po magpakasal? Kung may green card na po dati pero expired na, paano po? Okay, so basically you need a visa to be able to enter the United States. In your case, expired na yung green card. So I'm not so sure if you will be eligible for returning resident. I would recommend that you consult with a lawyer if you will be eligible for that. Kasi you really need either a green card or a travel permit or a visa to be able to enter the US, even if the intention is magpakasal. No? So again, if you could actually give me a follow-up information on that, I would be happy to give you a follow-up answer. Ma'am Leia, for a sibling petition, would there be any problem if my sibling will get married or dapat single or his or dependents will be included in the petition? So for a sibling petition, the waiting period now is about 23 years. It doesn't matter kung magpapakasal siya or single siya at the time. At kung may anak man siya at the time of the interview who will be below 21 years old, then those children will be included in the petition. Attorney, is there a chance for me to secure documents from OEC if my H1B refuses to validate my job order with Polo Washington? Okay. So, marami kasing ways to get the OEC certificate, right? So, if your employer is still within that maximum of 5 employees allowed to get OEC, then hindi siya necessarily dadaan sa Polo, right? Pero kung you are still within the direct hire status, then wala ka talagang magagawa kung yung employer mo hindi magko-comply sa Polo process. So it could be a problem. So I would recommend that you coordinate directly with your employer to be able to pass through the Polo process requirement. Actually, Attorney Nick, pwede po ba ma-petition yung spouse if I am Eb3 visa holder kung kasal kami sa China, not in the Philippines? So the general rule, boss, is marriage valid anywhere is valid in the US for immigration purposes. So it doesn't matter kung sa China kayo kinasal, you just have to make sure that it's actually translated into English. And since kung Eb3 visa ka, I would presume you are still a green card holder, and since current pa naman ang spouses of a green card holder now, yes, you can file a petition for your spouse. The waiting period will be about 2 years. Moises, kapatid ko po, J2, then 21 years old na siya. Ano po bang gawin niya? Okay, there is such thing as applying for IJA with the Department of State as the interested government agency, pag ang only reason is na magti-21 years old na siya. So I would recommend that you consult with a lawyer, boss, to discuss the details on how you go about that. But there is a chance that they will be approved, especially kung ang applicant is into school and so on and so forth. So pwede nilang i-apply yun for a waiver. While in the US, Vincent, under EB3 and you want to buy out your contract after 1 year of working with them, how will it affect your citizenship application after 5 years? Generally, if you are able to work for your employer for 1 year na, I don't think there is a problem for you to apply for citizenship. So, nagkakaproblema lang naman yung mga magbabuy out ng contract. So, if pag kunwari, pagkadating mo within 3 months, umalis ka sa employer mo or within 5 months, 6 months, umalis ka sa employer mo because there is a problem that a potential problem that you might be accused of fraud, no? That you really did not intend to work for your petitioning employer, ginamit mo lang sila para makuha yung green card mo, then you let them out, no? So, but 1 year is more than, is a good time enough to justify na you really intended to work for them. But for whatever reason, you decided to buy out your contract. Justin, I stayed in the US as a tourist and filed an extension. I stayed there for about 10 months. Magkakaproblema po ba ako sa Eb3 sa interview sa embassy? So for if your extension was approved, then it should not be a problem, right? And even assuming for purposes of conversation that you stayed unlawfully present in the US, for as long as the total number of days na unlawfully present ka is not more than 180 days, then it should not be a problem of getting your immigrant visa at the embassy. So, but based on fact pattern mo, I don't think you have a problem. Hello, Sir Emerson from Iligan City. Ilagan City, Isabela. Hello po. Adia, good evening. I'm a J1 working on a waiver. In case po ma-deny ang waiver and then planning to appeal, can we still stay in the US through expired na visa ko that time? So I'm not so sure if you are on the NOS route or the exceptional hardship route. Because in either case, you have to maintain status, ma'am, no? So ibig sabihin, if your visa is about to expire, you should actually apply for a change of status, whether from J1, J2 to tourist visa for the time being that you are actually waiting for the decision on your waiver application. Rex Tagaban, good evening. I have approved petition I-140 since 2007. Do I have a chance to get back by using approved petition? Yes. If your petitioner is still interested on pursuing your application, then you just have to inform the NBC that you are willing to pursue the process, or pag yung original petitioner mo hindi na interesado sa'yo, another petition could basically file a new application for you but recapture the priority date mo para hindi ka na maghihintay ng matagal. Greg, pwede po bang humanap ng ibang sponsor ng J1 visa? Paghanap ng ibang sponsor, yes, but you might be subject to another program which might subject you to another 212E restriction. But to answer the question, yes, you could still file for another J1 sponsor. Is it advisable? Not necessarily, but in worst case scenario, yes, you can find another sponsor. Tricia, is there a chance I can bring my kids with me in the US? My parents petitioned me under unmarried daughter over 21 years old. When they filed the petition, they also applied for my kids. So, is there a chance I can bring my kids with me? Yes po. Ang tawag sa kanila, derivative beneficiaries, no? So again, kagaya na sinabi ko kanina, for as long as they are unmarried and below 21 years old at the time of your interview, they can go with you in the United States. They are part of that petition filed by your parents. Facebook user, my I-551 evidence po ako, naka-enter ko lang ng US last November 28, but uuwi po ako ng Philippines by March. Wala po bang green card? Wala pa po green card ko. Wala po bang magiging problem pag lumabas ako ng US, pagbalik ko after 3 months? Boss, if you actually read your visa stamp, in the middle portion of your visa stamp, it actually says, this serves as your green card for 1 year upon officer endorsement. It only means na on the first entry mo using that immigrant visa, that visa stamp will serve as your green card for 1 year. So, hindi ka magkakaproblema because you can use the same stamp to be able to re-enter the United States. Can a private and college, give me a second. Thank you for joining us here. Pasensya talaga pag hindi ko na mabasa yung mga messages nyo kasi medyo marami-rami din yung questions. Can a private and college preparatory high school petition me for an H1? they are affiliated with the Middle States Association of Colleges and Schools. Are they CAP exempt? Um, I cannot I cannot answer this question categorically as yes or no kasi marami, even a private employer who are actually affiliated with non-profit organization and so on and so forth who are tax exempt could still argue that they are tax exempt, no? But generally speaking kasi, pag private institution, ang petitioner mo, uh, hindi very clear by saying na, yeah, they are not eligible or they are eligible, no? As a lawyer, I still would want to look into the ano bang are again, maraming variables for me to be able to answer this question. So I would recommend that you consult a lawyer to really check if they are CAP exempt. But generally, pag private employer ka, you are not CAP exempt. But I'm not saying that holds 100%. So I recommend you consult a lawyer. What are the current opportunities for Pinoy lawyers in the United States? Hello, boss, no? So I'm a Pinoy lawyer before I entered the United States. So for as long as you pass the bar in the United States in any of the state, in my case, I took the bar for New York, and then you can explore, no? If a law office will be interested in hiring you, there are a lot of US visas available for lawyers for you to be able to work in the United States that will give you eventually a work visa, a green card, or citizenship thereafter. So good luck. Wishy Cabs. Hello ma'am, kumusta? If naka-receive na po ako ng approved H1b but needed ng waiver para ma-change ang status, valid ba ang paper na natanggap ko for 3 years? Right now, on the process to get another waiver, I'm planning to file for exceptional hardship. How long po ang pag-process ng exceptional hardship? Hindi pa ako alaganin. Okay, if naka-receive na ako ng approved H1b but needed ng waiver para maka-change ng status, valid ba ang paper na natanggap ko for 3 years? Okay, medyo maraming aspeto yung tanong mo, ma'am. No? If your H1b approval notice that says your H1b has been approved for 3 years, then the approval notice is valid for 3 years. But ang sinasabi, normally in that kind of notice that, hey, your change of status is not approved unless you provide a waiver or unless you go home to your home country to prove that you need to comply for the 212E requirement. Yung ganun kasi ang requirement, ma'am. No? Then you cannot use effectively the approved H1B approval notice kasi nga may precondition ka pang i-comply. In your case, it's the waiver requirement. Okay? But to the question of valid ba yung H1B approval notice na yun? Yes. And it is valid up to the time na sinasabi niya na valid yung H1B mo. No. So, how long will the exceptional hardship be approved? So, I'll just assume na meron kang ground for exceptional hardship. Then, the processing time now ngayon for exceptional hardship is 9 months to a year. Dayan, is there a chance for me to secure documents for OEC if my H1 employee refuses to? I think I answered the question a while ago. No? Moises, J2 kapatid ko, tuwin na siya, ano pa pwedeng gawin? My fiancé, J. Uy. My fiancé is a US dual citizen. We have an ongoing fiancé visa at NBC. I'm pregnant. What will happen po? So, if you happen to have a child already by the time of your interview, so then that child will automatically be eligible for citizenship. There's another application that you need to comply called the CRBA. Pero pag so again, yun yung magiging remedy mo pag nanganak ka before your interview. So don't worry about that. The child will automatically be a US citizen. There is just another application that you need to comply, which is mabilis lang naman. Direct embassy processing kasi. Ma'am Vivian, hello Ma'am Vivian. I petitioned my daughter to be in the United States. She is currently approved. Can she visit her as a tourist? Ma'am, depende po kung ma-approve yung tourist visa niya. So, until then, she needs to wait for the visa. Facebook user, I petition my... Sandali lang. I petition my 2 sons, 17-year-old and 10-year-old. I am the petitioner and I am already a US citizen. How long it takes kaya attorney? Maraming salamat po in advance. So, ma'am, generally, ma'am, nasa 9 months generally from approval sa USCIS, right? And then it normally takes about 4 months to stay at the NBC before the NBC give you the interview date at the embassy. But at the embassy naman, depende na ngayon kung gaano sila kabilis. But your case is a priority case, so don't worry about that. Hello, Ma'am Elaine, Sir Eric, kumusta po? Arlene Rojas, can a spouse stay in the US while ongoing adjustment status from tourist to? Yes. So even if expire na yung I-94 niya, for as long as the green card application has been processed, then they can stay legally in the United States. Step. Any update po kaya regarding Eb3 interviews dito sa Pilipinas? Mabagal talaga yung Eb3 ngayon. At the embassy. Part of that is because of the COVID situation in the Philippines. So maraming factors that could affect the scheduling ng Eb3. But I heard starting last month, nagmo-move na rin yung Eb3 applications in the Philippines. Moises, hello my brother. Okay, bumabalik na. Ina, what if PR po ng Australia tapos may balak po mag-tourist visa dyan sa US? Pero may beneficiaries, wala po bang problema po? Again, the tourist visa application really depends kung at the time of the interview, if you would be able to prove to the officer that your visit to the United States is temporary, pero may pending petition ka, right? So again, depende kung ano bang klaseng immigrant petition yung pending sa'yo. If kung ako yung officer and I know that you are just waiting 1 year, 2 years before your immigrant visa, then chances are I will use that against you. Pero kung kunwari ang immigrant petition mo is by a sibling, which the waiting period is 23 years, and you will be able to convince the officer that your visit is temporary, and you have strong ties to in Australia, then you will have a chance to be approved of the tourist. So, depende yan. Maraming factors to consider when you're applying for tourist visa. So, good luck on that one. Justin, I stayed in the US as a tourist and filed an extension. I stayed there for about 10 months. Okay. Bumabalik yung mga questions. Right? Giselle, may idea po kayo on how long it will take po doing security check on I-130? Okay, this is an interesting question. You're actually talking about security checks. The problem when your case is placed on security checks though is that you lose transparency as to what the government is looking as far as your case is concerned. Ngayon, what you can do is to continually communicate with the USCIS if you would want to provide them with your latest criminal police certificates, or if you are in the Philippines, NBI clearance, just to give them that, hey, I am not a criminal, I have no bad records and all that. But to answer the question, there is no timeline once your case is placed on security check. And even if you're going to call your congressman or your senator or call USCIS, they are not going to give you the reason why your case is placed on security check. Hindi naman ibig sabihin na you are placed on security check that you have a criminal record, because it could be possible that your case was randomly selected to be placed on security check as part of their process. But there are also cases where their case has been placed on a security check kasi nasa list talaga sila ng people with Mark X na, no? So may mga suspicion of illegal activities. So, but yeah, it could be a long wait for you. So patience is a virtue in those cases. But again, as what I recommended, you could continuously communicate with USCIS by providing them that you have you have no criminal records as far as your circumstance is concerned. Says, kaka-expire lang po ng green card August 2020. Ano po kaya process with that? Ma'am, you might be able to apply for returning resident if the only reason bakit hindi ka nakabalik sa US is due to COVID. So, malakas ang chance mo na makuha mo ulit yung green card mo, even if expired na siya. So, if you would want to consult a lawyer, you can do that. But the term is the returning resident application. Michelle, ask ko lang po, nung first year ko na J1, subject ako ng 212E. Then umuwi ako ng Pilipinas to renew my visa for second year. At nagalagay po doon, ay not subject to. Ngayon po, fourth year ako. na hindi ako nakauwi sa Philippines for visa renewal for dahil sa pandemic. Bali, na-extend lang ang TSN. May possibility mo pa kaya na ma-waive ako? Ma'am, the best way to really answer your question categorically is you might apply for advisory opinion. Ang nakikita lang namin na trend, if you are getting an advisory opinion on, lahat yon or majority non will come out that you are subject to the 212E. So in that case, you might apply for a waiver. But before you would apply for a waiver, you have to know first, ano bang magiging basis mo? May anak ka bang US citizen? Are you married to a US citizen spouse or a green card holder spouse? Kasi yun yung mga pinaka-common na ground for a waiver. Right? So, to answer your question, I would recommend, ma'am, that you consult a lawyer to answer specifically your query. But the best remedy for you is file for advisory opinion with the Department of State. Yoji, hi Tony, paano makapag-apply dyan dahil pending petition po sa uncle ko? Paano makapag-apply dyan dahil pending petition po sa uncle ko? Paano ang pag-process nito? I'm not so sure if I understand the question, right? So, you have a pending petition from your tito. So, ibig sabihin, yung parent mo ang pinetition ng tito mo and you are just a derivative. Ma'am, can you just give me more facts to your question? While in the US under Eb3 and you want to buy out, okay, I think I answered that. Michelle? How long to process sibling petition? 23 years waiting for Filipinos, boss. Jen, is there a chance for a J1 to adjust status to H1b even if subject to 212E? If you're subject to the 212E, you need a waiver before you will be eligible for H1b or immigrant visa. Attorney, kapag holder ng B visa, tas po, nag-accompany po ako ng pinsan ko going to the US, petitioned by his mother, pwede po kaya mag-convert ito sa H1B kung i-hire niya ako as company, as a manager. Okay, boss, medyo careful lang dito, no? Kasi there is a prohibition that if you enter the United States on a tourist visa, you cannot change your plan within 3 months from arrival to the United States. So, ibig sabihin, pagdating mo sa United States on a tourist, do not change status, do not get married, do not file for a green card within the next 3 months. Kasi fraud yon. So, if ever man mag-change yung plan mo after the 3rd month or the 4th month, then just make sure that you consult a lawyer para lang guided ka lang, boss, no? But again, just to let you know that there is what we call the 90-day prohibition of not changing your plans if you are entering the United States on a tourist visa. So, just time check. I have 20 minutes remaining before I will end my Facebook Live. So, kung may mga tanong kayo, just write them down because I really have to have a clear cut on ending my Facebook Live today. I promise already that at least once a month, as much as possible, if I can do an open session just to answer questions on Facebook, because most of the time, I do Facebook Live on specific topics, right? So, but at least sa ganito, I could cater to any question that you would want to raise. Jancy, good eve, attorney. Unsay counting kung mag-apply og citizenship? On the day nakuha nimo imong 2 years na green card or 10 years na green card? Okay, good question, right? When you apply for citizenship, the starting point is since you become a green card holder. So, when you look into your green card, may nakasulat doon that resident since. So, when you receive the 2 years, that was your initial date nung natinggap mo yung green card mo. Even if you receive the 10-year green card na, yung resident since hindi nagbabago yon. So, to answer your question, you have to count on the date where you first receive your green card. Ngayon, sagutin ko na yung follow-up questions dito. Kailan ka eligible for citizenship? If you got your green card because you are married to a US citizen, then you are eligible for citizenship 3 years from the time you get your green card and you are still married to the US citizen. But if you are no longer, if you did not receive your green card through marriage, or if you are no longer living or married to the petitioner mo on a family base, then you have to wait 5 years from the time that you receive your initial green card. Jasmine, I'm from UAE. I already got my immigrant visa. I'm due to deliver end of this month. What is the law for newborn after visa issuance? Okay. So, ma'am, don't worry about that. You will still be able to bring your infant with you coming to the United States. There is a special provision for that, to be able to bring your child without a visa. So, if you would want to know the details of that, I recommend that you consult a lawyer. But the good news is you will still be able to bring your child without the need of filing a different petition. Arlene, which spouse petition is faster po? Pag green card holder or US citizen? So, mas faster kung US citizen, right? Kasi kung green card holder spouse, 2 years waiting yun. Whereas kung US citizen, about 1 year lang. Now, ngayon, another complexity of that is, pagdating sa US Embassy in the Philippines, if you are applying for a spouse of a green card holder, then your case is not a priority. And unfortunately, we have cases where people are already waiting more than 1 year to 2 years. So, guys, it's already almost 10 o'clock here and people are still calling our office. So, if you are watching my live, please don't call me because the office is already closed, right? So, thank you for not calling at 10 o'clock. So, ma'am, to answer your question, mas mabilis pag spouse of a US citizen. Cyril, attorney, wala pa po yung green card ko. Pero I-95 evidence PR po ako. Kakaintay ko po ng US citizen, IR1 visa. Okay, I think I answered that question a while ago. Attorney, I'm not subject to 212E, now married to a permanent resident, but found out na may felony siya 20 years ago. Makakaproblema po ba kami pag-process ng green card? Ma'am, generally no. So, the inquiry about the criminal ground as a ground to deny a green card application is heavily on the beneficiary. But the only case where the criminal record of a petitioner matters is kung ang felony ng petitioner is around sexual in nature, right? So, pero outside of that, it should not be a ground to deny your green card, and that person should be able to file a green card application for you. Kung ikaw, I would recommend that you get a lawyer's assistance when you file for a spouse visa para lang guided kayo and to give you peace of mind. Okay, Yoji, I would not talk about fees kasi every law office naman iba-iba, right? And again, just make sure that yung agency na ka-work with mo is legit. Yun lang yung masasabi ko. Hello ma'am, kumusta ang yung Virgin Islands? Ma'am, kumusta ka na ma'am? Ongoing pa immigrant interviews ngayon sa US Embassy, kahit mataas cases sa Manila. For immigrant petition, if the application ma'am is based on spouse of a US citizen, yes, tuloy-tuloy pa rin yun. But if you're talking about employment-based, medyo bumagal. If you are talking about spouse of a green card holder, medyo mabagal. The US Embassy in Manila has already been sued as a class suit, but it didn't, the court favored the government at hindi pa rin nila ma-force ang embassy to take cases based on spouses of a green card holder. Hello Ma'am Eileen, kumusta po? Salamat po pala sa tulong niyo na maayos ang okay po, our pleasure po. Thank you. Josephine, nakapag-file ng petition yung husband ko for alien relative pero wala pa pong case number. Can I apply for an H1b visa? So, I'm not so sure if your spouse is a US citizen, right? Kasi kung US citizen yung spouse mo or even a green card holder, and I'm not so sure if you are in the United States. Kasi yung H1b visa kasi mabilis ma-approve yun, no? Again, if you are in the United States, it doesn't make sense for you to apply for H1B kasi you could apply na for your green card and then eventually you will get your work permit before you can get your green card, no? But if you are outside the United States, then somebody file an H1B for you, yes, you could still get an H1B even if meron kang pending I-130 application. Ma'am Eileen, ano po ang the best way or pinakamadali na ma-petition sa US citizen sa Pinas fiancé? Or pag ang petitioner US citizen po, generally speaking, mabilis yung fiancé visa. The problem ngayon is pagdating sa embassy, in Manila, hindi nila pinaprioritize, ma'am, ang fiancé visa. So, some of our clients or fiancé visa in general has not been handled by the US Embassy in Manila for about more than almost 2 years na, ma'am, since the pandemic started. But recently, they just opened the fiancé visa since December last year. They are now starting scheduling the fiancé visa. And I hope tuloy-tuloy yun. So kung tuloy-tuloy yun, mabilis talaga ang fiancé visa. But again, I hope the COVID situation in the Philippines will be improved para mas mabilis pa rin yung application ng fiancé visa. But other than that, I would recommend filing the spouse of a US citizen kasi priority case pa rin yun at the Embassy ng Manila. Cheryl. Okay, tinatag lang pala yung mga friends yan. So, Dodol. So again, guys, I have 15 minutes left. Dudoy, we already filed Form 751, Petition to Remove Conditions on September 2019 and received my extension of October. However, my wife died last and have not yet filed for a waiver because there was a problem in the death certificate. I have already filed a request for correction. I'm still waiting for the amendments on the certificate. Ang question ko, attorney, pwede bang hintayin na lang ang corrected copy? So you could basically, ma'am, kung na-file na yung 751 mo, you either the best way to handle this is you could submit an application filing an amended Form 751 on the office handling your 751 to let them know na you are now filing self-petition based on the death of the spouse, no? Or you could also wait na, kasi mabibigyan ka naman ng 24 months extension no? Now, if you will receive a request for evidence, then you can inform them that the petitioner already died. Other than that, you can just wait for the extension. Kung ipatawag ka ng embassy for interview, you can show na the petitioner already died. But at the end of the day, you would still be able to get your 10-year green card. So wait for the correction. There is no urgency for you to letting the USCIS know. You can wait or you can proactively tell them. But at the end of the day, that doesn't change the fact that your 2-year green card will only be extended to 24 months. J. Okay. Ayana. I'm J1 po, not subject to it. Now married to permanent resident, but found out na may, okay, ayan, salamat siya. Can we still appeal our petition? My parents are now in the US. They have been approved. However, on my case was not included dahil above 21 na and now married. This is via sibling petition by our auntie. Okay, so you are basically now excluded from that application. So what I would recommend, yung parent kasi need to be a US citizen to be able to file for married children. So, kung i-file ka naman ng sibling mo, 23 years waiting yun. So, the best strategy for you is to wait for your parent to become citizens, then they will file a new petition for you. In that case, mga 15 years waiting pa rin. Better than the 23 years waiting period. Good luck on that one. Or you might want to explore the employment visa route. Jed, can the H4 holder use H1Bs for adjustment of status? Yes, pero depende yun, boss, kung if you are already in the extended period ng H1. Kasi yung H1 kasi is have a maximum term of 6 years. Pero pag kunwari, you are already on that end stage and the H1B applicant o visa holder na i-file na or nasimula na yung green card application process niya, then the H4 visa holder can apply for a work permit. So for a more detailed conversation or discussion about your case, I would recommend that you consult with a lawyer. Leia, can someone with a tourist visa enter US and accompany employer if in the... Okay, I think I answered that question a while ago. Josephine, file ko na rin yun. Ano, sagot ko na? Can H4 visa holder H1Bs for adjustment of status or the H1... okay. Can the H4 holder use H1B I-140 for adjustment of status or the H4 needs to have his own I-140? So, boss, kung yung H4, pag final na ang green card ng H1 mo, dapat the H4 are included in the green card application. Meaning, their individual H1 green card application should be filed together with the H1's green card application para sabay-sabay na kayo mag-interview. So to answer the question, no, the H4 does not need a separate I-140 kasi kasama naman siya doon sa I-140 nung H1. Hello, Ma'am Susan, nandyan. Kumustang Florida po? Nung pinetition po ng mom-in-law ko, bro-in-law ko, di pa po US citizen. Naging US citizen na po. Ilang years po, maliles. Okay. Okay, I don't have the numbers here though, but I think the difference between, give me a second. The difference between F1, married children of US citizen, they are now processing March 2012 applications. Kaysa doon sa married sons and daughters of a US citizen. Sorry, I lost that. Nung pinetition po ng mom-in-law ko, yung brother-in-law ko, hindi pa po sila US citizen. Ngayon po, naging US citizen na po sila. So, una, there is no category for married children of a green card holder. So, yun automatically converted. Sorry, hindi pa sila. So, you are actually talking about unmarried child of a green card holder, then nagiging married child of a US citizen. So, you are basically looking at F2B to F3. So, yung F2B mo, ang pinaprocess nila ngayon, 2011, October. Ang pinaprocess ng F3, which is the married sons and daughter, 2022. So, mas matagal, ma'am, ang hintayan ninyo because based on the visa bulletin, that's 9 years difference. So, again, I don't know kailan na i-file to be able to really say ano yung time difference. But generally, the two categories, 9 years difference yung waiting period na. What if J1 visa holder now has been teaching for 5 years in Florida? What I'll do to avail of an H1b? If you are not subject to the 212E, Noel, then you will be able to be eligible for H1b if meron kang employer willing to file a petition for you. But if you are subject to the 212E, then you need a waiver. Jed, can the H4 holder use? Okay, nasagot ko na yan. Kathy, my mother applied for a waive interview in November, but then she was required to appear in the U.S. Embassy. She was denied for renewal, but her tourist visa will expire in October 20. Can she still travel to the United States? Okay, let me step back. My mother applied for a waive interview in November, but then she was required to appear in the U.S. Embassy. She was denied for renewal, but her visa will expire in October. Can she still travel to the United States? Okay, so I'm not so sure what type of visa we're talking about here now, but I presume this is a tourist visa application. So I understand that you could waive the interview based on a renewal of a B2. So, kung na-deny siya sa renewal, normally kasi tinatatakan ng consular officer yung visa niya ng either revoke or canceled or denied. But if that visa is not stamped, revoked, or canceled, and it is still valid until October 2022, it means that it can still be used validly by your mom. No? So just make sure, ma'am, na walang stamp yung revocation or cancellation yung B2 niya. Other than that, she should be able to use the visa because it is still valid. Okay, 5 minutes more. And I'm sorry I cannot read all your questions. So I will just try to read whatever question I can get in the next 5 minutes. And again, thank you guys for joining in. Alam kong matagal akong nawala. So let's go. Federos, okay lang po ba mag-file ng yung BF from US for fiancé visa for me if I had just got my nullity in the marriage here in the Philippines? So, una, good thing that nakuha mo na yung nullity of marriage mo. The only question is, have you met your boyfriend within the last 2 years so you could start your fiancé visa. So if the answer is yes, then you can file the fiancé visa now. So good luck on that. Attorney, good day po. Ano po ba ang tamang gawin or tamang visa na in-apply ko kung sasamahan ko po dyan sa US yung pinsan ko na petition ng US citizen niya na mother? Ako po ang authorized guardian niya. So, I would recommend, ma'am, that you will apply for a tourist visa and then ang reason mo is accompanying relative, no? So, then just explain yourself to the officer at the time of the interview that you are the guardian of the US citizen applicant, no? Say, good luck on that one. James, if settling an estate po of a deceased immigrant spouse, pwede pa ba kumuha ng B2 visa? So, I think, James, you are asking if settling a estate is a valid reason to apply for a B2. So, any purpose of applying for a tourist visa na ang intention mo is just to temporarily visit the United States, yes, that is a valid reason to apply for a tourist visa. John Bay, I am an immigrant visa applicant under category for RI5. I've been interviewed already and had twice medical exam. I'm in the Philippines. All my files are lawful permanent residents. Okay, so boss, kumusta? I'm not so sure kung anong nangyari doon sa interview mo. But it seems like you have problems with your medical exam, no? So, I think kulang yung fact pattern mo, boss, para for me to answer your concern. Hello, Sir Nino Orbina. Hello, boss. Kumusta po? Shing, yung DS-260 namin, ng husband ko ay naka-address sa Philippines. Ngayon, nasa US na ako. Pwede po bang magpa-change address since nandito na ako ngayon? You might want to consider, ma'am, adjusting status here, no? Instead na mag-apply ka ng interview at the embassy. So again, depende ko anong klase yung immigrant visa petition mo. So, I would recommend, ma'am, that you consult a lawyer for better guidance. But to answer the question, can you change address? Yes. But what is the purpose of having that request? No? Kasi kung nandito ka na sa US, you might be eligible for applying for adjustment of status, meaning dito ka na mag-a-apply ng green card. Or kung meron ka ng interview date, then I would recommend you go back, apply for interview there kasi mas mabilis mo pa rin makuha yung green card mo kaysa mag-apply ka ng green card in the United States. So, that would be my recommendation. AJ, I am on my 4th year J1 visa with US citizen child. May right timing po ba sa pag-apply ng hardship? When is the right time po? So, if your basis of applying for the waiver is having a US citizen child, then ang recommendation ko, if you're already in your 4th year, apply. No, the exceptional hardship kasi waiver based on the US citizen child, ang processing time is 9 months to a year. So, if you are already starting your 5th year coming June, then apply for the waiver by June. Para lang meron kang enough time to get your waiver approved. Jasmine, I think nasagot ko na yan. My parents have tourist visa. I'm a US citizen and I want to petition them. Can they come over as a tourist and apply when they are already here? So to answer the question, ma'am, yes, you can, but be very careful with that. Kagaya na sinabi ko kanina, there are prohibitions for tourist visa holder not to change their plan pag nandito na sila sa US upon arrival, right? Because the officer could accuse you of fraud. So I recommend that you consult a lawyer for better guidance on how you can better handle that plan. No? But to answer your question, you could start the process now or if you wouldn't wait. Ang problema kasi doon is if they are tourist visa holder and it really is the original plan to use the tourist visa to enter the United States, but eventually they will apply for a green card, that's fraud. And that's the intention of the 90 prohibition rule kasi nga ina-abuse yung terms ng tourist visa. So again, I would recommend that you consult a lawyer para better guided kayo. Kitoyski, my mom is for interview but was delayed dahil sa medical po. However, ngayon, clear na siya. Kaso until March 8 lang validity ng medical niya. Wala po siyang schedule for interview. Mail US Embassy already. Okay, so the problem with an expiring medical exam though is it's not a valid ground to expedite a case. Ang mangyayari dito, once your mom receive another interview date, then she will really be required to get another medical exam if by the time of the new interview date expired na yung medical exam niya. But again, you already mailed the US Embassy, then let's see anong response ng Embassy. I hope you will be able to get a new interview date before the medical exam expires. So guys, I really am so sorry. I have another consultation after this. That's my last question. And again, maraming salamat po. Till next time, I will be spending more, siguro 1 hour and a half in our next session. So, thank you very much. Magandang gabi po dito sa New York or in the East Coast. Magandang umaga po sa Philippines. Maraming salamat po. Till next time. Bye-bye.